Trump Legal Cases Digest, December 20, 2023. Can the SCOTUS be more supreme than Trump? Navigating Donald Trump's legal entanglements demands a keen eye as the former president contends with an array of federal and state trials, both civil and criminal. This week, as the New York civil fraud trial approaches its conclusion, the focus shifts to the Supreme Court's considerations that could impact Trump's federal trials related to the 2020 election interference. Additionally, there is growing attention on the Supreme Court as it examines two cases that could potentially delay Trump's federal trial for interfering in the 2020 election. The Colorado Ballot Ban is a third potential case for the Supreme Court. The election interference trial was originally scheduled to begin in Washington on March 4. Here is the latest update on these ongoing developments. Joseph Fisher's January 6 legal challenge and its implications on Jack Smith's case. The Supreme Court's recent decision to take on Joseph Fisher's case, seeking clarification on the definition of obstruction to an official proceeding, has far-reaching implications for over 300 Department of Justice cases, including the one led by special counsel Jack Smith against former President Trump. Fisher's attempt to dismiss a specific charge related to the January 6 events. Fisher, who was among those who entered the Capitol on January 6, 2021, has been charged with obstructing an official proceeding along with several other charges. He is now attempting to have the specific charge of obstructing an official proceeding dismissed, which carries a maximum prison sentence of 20 years. This prompted a legal saga, with a Trump-appointed judge initially dismissing the obstruction charge. However, the U.S. Court of Appeals reversed this decision, asserting a broader interpretation of the statute beyond document tampering. Fisher has appealed once again, and the Supreme Court is set to issue a decision before June 2024. It is uncertain how the court will handle the case, but the resolution of this pivotal case is expected to shape the legal landscape, potentially impacting Smith's high-profile election interference case against Trump. Jack Smith's election interference case is on pause. The U.S. Supreme Court is currently considering whether to take up Trump's appeal for presidential immunity. Trump's legal team has been attempting to get the Department of Justice's federal election interference case dismissed by arguing that Trump is protected from prosecution for actions he took while he was in office. Initially, Judge Tanya Chutkan rejected the argument of absolute immunity, but the DOJ's case is now on hold while an appeals court decides on Trump's claim. However, before the appeals court could decide, Smith took an unusual step. To avoid delaying the start of the trial in March 2024, he petitioned the Supreme Court to consider whether a president has absolute immunity from criminal prosecution for any conduct committed while in office. Smith hopes to bypass the appeals court by directly going to the Supreme Court of the United States. Likely, the case will eventually reach the High Court anyway. While the Supreme Court has shown interest in the petition, it is not yet certain whether the case will be heard. The appellate court has also agreed to expedite the schedule, with a briefing due in early January. Two unprecedented cases will determine Trump's fate from the Supreme Court. As the year-end approaches, the Supreme Court grapples with two critical legal questions concerning former President Trump's alleged misconduct, with significant implications for the upcoming election and potential historic constitutional precedents. The recent ruling by Colorado's Supreme Court, deeming Trump ineligible under the 14th Amendment for the state's 2024 presidential primary ballot due to his role in the Capitol attack on January 6, adds a unique layer to the legal complexities. Simultaneously, Trump's attorneys are poised to argue before the High Court that the former president is immune from criminal prosecution related to actions leading up to the same insurrection. These unprecedented legal challenges, involving a conservative court with 3 Trump appointees, raise constitutional issues and have far-reaching consequences, prompting urgent calls for definitive judicial resolutions before the 2024 election campaign intensifies. The legal landscape further unfolds with special counsel Jack Smith's plea for a swift Supreme Court ruling on Trump's immunity claim, crucial for the scheduled March 4 trial. The grand jury's indictment of Trump on charges related to subverting the peaceful transfer of power underscores the unprecedented nature of these legal proceedings. As the court considers the interplay between constitutional provisions and the unique circumstances of a former president facing criminal charges, the decisions reached will set precedents and potentially impact the trajectory of Trump's legal battles, influencing not only the upcoming trial but also shaping the broader legal framework for presidential accountability. The urgency to resolve these matters before January 6, 2025, is emphasized for the sake of political stability, ensuring voters have clarity on the eligibility of the candidates they support, and averting potential disruptions to the democratic process. Trump's indictment or disqualification from the ballot can strengthen his base. As the Colorado Supreme Court's decision to declare Donald J. Trump ineligible for the state primary ballot unfolds, the immediate political repercussions are apparent. Trump's allies swiftly took to social media, labeling the ruling an outrage that requires rectification by the U.S. Supreme Court. The court's assertion that Trump incited the January 6, 2021, insurrection, prompting his potential removal from the ballot, introduces a nuanced dynamic. Even if he remains on the ballot, the assertion that Trump incited an insurrection could haunt him in a general election, yet in the Republican primary, it may be viewed as Democratic overreach, potentially bolstering his lead in crucial early contests. Trump's resilience in the face of legal challenges is a hallmark of his political strategy, leveraging a narrative of victimhood to rally his base. Since March, he has deftly used legal troubles, including 91 felony charges, as rallying points for fundraising and galvanizing his supporters. Trump's campaign has already folded the Colorado ruling into this narrative, framing it as a political conspiracy to interfere with the election. Even critics acknowledge the potential impact, with some predicting that the U.S. Supreme Court might unanimously overturn the Colorado ruling, further amplifying the victimhood narrative that Trump's team eagerly embraces. Congress uproars following Colorado court disqualifies Trump. The Colorado Supreme Court's decision to disqualify former President Trump from the state's 2024 ballot has triggered intense reactions from members of Congress in both parties, reigniting a national debate about the January 6 riot and the extent of the former president's accountability for the violence. 4 of the 7 judges on the court invoked the 14th Amendment, barring individuals who engaged in insurrection or rebellion from holding office, marking Colorado as the first state to apply this prohibition to Trump. The case is poised to reach the U.S. Supreme Court, with the Trump campaign intending to appeal and the Colorado judges issuing a stay until January 4 for federal adjudication. Similar cases are progressing in numerous other states. House Speaker Mike Johnson, R-Law, criticized the ruling as a thinly veiled partisan attack, expressing confidence that the Supreme Court will overturn the decision. House Republican Conference Chair Elise Stefanik, RNY, denounced the Colorado Supreme Court majority as 4 partisan Democrat operatives, predicting that the ruling will strengthen President Trump's campaign. Senator Tom Tillis, RNC, introduced legislation aimed at penalizing states making such rulings, proposing to withhold federal election administration funds from states misusing the 14th Amendment for political purposes and asserting the Supreme Court's sole jurisdiction over such 14th Amendment cases. While Democrats supporting the case against Trump's eligibility applauded the ruling, concerns were raised about potential political violence in response to the decision. House Oversight Committee Ranking Member Jamie Raskin, DMD, emphasized the ruling's legal foundation and potential enforcement challenges, cautioning that acting against those who have betrayed their oath may lead to further violence. "This is the problem," he stated. "Whenever the police and prosecutors go after organized crimes or violent gangs, there is always the fear that enforcing the law against them could lead to further violence. It's something America needs to be prepared to stop." The complex legal and political dynamics surrounding this issue continue to shape the discourse on Trump's political future in the aftermath of the January 6 events. Prosecutors accessed Trump ally Scott Perry's phone on election case. In a significant development, Chief U.S. District Judge James Boasberg, who oversees grand jury matters in federal court in Washington, D.C., has ordered Republican Congressman Scott Perry to surrender almost 1,700 records from his phone to special counsel prosecutors, shedding light on his potential involvement in Donald Trump's endeavors to overturn the 2020 election results, including the removal of Justice Department officials. Boasberg's decision allows prosecutors access to the majority of the records extracted by the FBI from Perry's phone. The court-mandated production includes 1,656 out of 2,055 records, and the U.S. Court of Appeals for the D.C. Circuit has directed Perry to individually review these materials, safeguarding those protected by the speech or debate clause, which shields members of Congress from legal consequences linked to their official duties. These records encompass Perry's discussions related to influencing the executive branch, state officials, and communications concerning efforts to impact the conduct of executive branch officials, including former Vice President Mike Pence. The purpose of these records in the hands of special counsel Jack Smith remains unclear, given the prior indictment of Trump in July without these materials. Perry retains the option to appeal Boasberg's application of the speech or debate clause. The ruling adds another layer to the constitutionally complex case, overturning a previous decision by Chief Judge Beryl Howell and reflecting the ongoing legal intricacies surrounding informal fact-finding by members of Congress and the protection offered by the speech or debate clause. Trump expresses anger and frustration after the ruling in Colorado. Election interference. Trump posted Tuesday night on Truth Social. In the aftermath of the Colorado Supreme Court's decision barring Donald Trump from the state's presidential ballot, the ex-president, unsurprisingly, took to his social media platform Truth Social to condemn the ruling and rally support. Trump expressed his dismay, declaring it a shame for our country and deeming it a sad day for America. Meanwhile, Noah Bookbinder, president of Citizens for Responsibility and Ethics in Washington, lauded the decision as historic, justified, and necessary to safeguard the future of democracy. Republicans, including Representative Elise Stefanik, rallied behind Trump, accusing Democrats of attempting to illegitimately remove him from the ballot out of fear of his potential victory in the 2024 election. The ruling has ignited a firestorm of reactions, exposing deep divides over the interpretation of constitutional principles and the perceived impact on democratic processes. The legal implications of the recent Colorado ruling have cast doubts on the Trump team's confidence in the Supreme Court's decision. Trump's Truth Social feed has already reflected this uncertainty by quoting Jonathan Turley, a conservative law professor at George Washington University who has previously testified as a witness for House Republicans in the impeachment proceedings against Biden. This country is a powder keg, and this court is just throwing matches at it. For people that say they are trying to protect democracy, this is hands down the most anti-democratic opinion I've seen in my lifetime, Trump referred to Turley from an appearance on Fox News. Trump edited out a part of Turley's interview where he acknowledged that while he disagreed with the Colorado court's decision, the events of January 6 were mostly negative. In my view, it was not an insurrection. It was a riot, Turley said. That doesn't mean that the people responsible for their day shouldn't be held accountable. But to call this an insurrection for disqualification would create a slippery slope for every state in the union. Amidst the fallout from the Colorado Supreme Court's decision to bar Donald Trump from the state's presidential ballot, Republicans are responding with forceful reactions and strategic moves. Presidential candidate Vivek Ramaswamy, vowing to withdraw from the Colorado Republican primary, has exerted pressure on his peers to follow suit, characterizing participation as a tacit endorsement of an illegal maneuver with dire consequences for the nation. Florida Governor Ron DeSantis has offered a distinctive perspective, suggesting that the decision is a calculated move by Democrats to galvanize Trump's base, setting the stage for a contentious general election dominated by legal battles. Trump, leveraging the ruling for fundraising purposes, underscores his narrative of being targeted by Washington, emphasizing the need for financial support from his base. As the Colorado court delays the implementation of its ruling until January 4, Trump's campaign spokesperson expresses confidence in a swift and favorable resolution from the U.S. Supreme Court, positioning the legal battle as un-American and calling for its conclusive end. The Colorado court's decision to disqualify Trump from office under Section 3 of the 14th Amendment, known as the Insurrection Clause, has sparked a contentious legal debate. The court argued that the clause, aimed at preventing those engaged in insurrection or rebellion from holding political office, disqualifies Trump due to his alleged role in inciting the January 6 attack. However, legal scholar Jonathan Turley contends that while Trump may have incited a riot, it may not meet the criteria for insurrection as outlined in the 14th Amendment. The case may be elevated to the U.S. Supreme Court, which, with its current conservative majority, has faced accusations of political bias. Trump's influence on the court is notable, having appointed 3 of the 9 justices. As the legal battle unfolds, questions arise about the court's impartiality and its role in deciding another Trump appeal regarding immunity from prosecution in the Washington, D.C. criminal trial related to the January 6 insurrection. The case not only puts Trump in the spotlight but also challenges the Supreme Court's reputation as a neutral arbiter of the law amidst a polarized political landscape. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.